tell me when? Oh, I'm going. Okay.
Yes, ma'am.
Good morning. Good morning, Your Honors. My name is Carla Miller of the Nashville Bar. I'm very happy to be in the town with the school that beat Alabama this year because I'm an Auburn graduate. So that was the bright spot of our season. So I wanted to thank you for the opportunity to appear in court this year on this occasion. We're here today on the matter of Haun versus Haun. Haun versus Haun is a divorce that was finalized in June of 2021. The parties had been married for 27 years, and I know that the court has read the briefs, so I'll just kind of cut to the chase since I now have 11 minutes and 30 seconds. The most contested issues before the court today are the issues of certain large amounts of monies that the intervening petitioners allegedly loaned to the parties of the divorce, Mr. and Ms. Haun. The Whaleys, the intervening petitioners, are the parents of Kristie Haun, and they, throughout these parties' 27-year marriage, were very kind and generous to these parties. One such occasion was when when Janet Whaley agreed to write a check for $120,000 that was to was to pay off the demand of the estate of the gentleman who had held the note. It was a written note. It was a demand note. And he passed away, and so did his wife, and her estate demanded payment on the note. So in order to get the Hauns out of trouble on that, and so that we wouldn't lose the property that had been security for it, they wrote a $120,000 check directly to the Imogene Gregg estate. And the Imogene Gregg estate then considered that deed done. The crux of the issue is whether the resulting arrangement between the parties, and at this point there's not really a dispute that there was some type of arrangement, even possibly for repayment.
Excuse me for
Yes,
interrupting. All four of these transactions, were they oral transactions? Were they
Yes.
oral transactions? Was there any writing memorializing the elements of these transactions?
No, Your Honor, but let me take one at a time, just real fast, to answer that particular question. I didn't mean to point, sorry. So on the $120,000, there is a check from the Whaleys, or Janet Whaley in particular, to the Imogene Gregg estate. There is no other writing of which I'm aware. I'm sure they'll correct me if I'm wrong. Then they're on the $78,000, which ended up being $73,000 after a $5,000 payment. There was no note. There was just checks that came from Janet Whaley out of her retirement account to the Hauns or Wholesale Auto. Then on the $19,670, there was no writing about repayment at all. The only evidence regarding the monies were 4 checks that were written in May, 2 written in May and 2 written in August, both in 2015. So 4 checks written in the middle of 2015. So that's the only evidence of the monies that landed in the accounts of the Hauns. And there was no written repayment agreement at all. Then on the last one, the $109,000 and some change that was associated with the Griffith Drive properties, 300 being a lot and 350 being a home. Mr. Haun doesn't actually dispute that ended up being a loan. Is secured by property, or it used to be. It's actually not secured by the property, excuse me. And he doesn't dispute that can stay with Ms. Haun. The issue there, and there's no agreement, to answer your question, Your Honor, there's no agreement in writing for the repayment of that.
Was there any verbal agreement for repayment?
There was a verbal agreement for repayment of the $109,000, and that was made between the wife, Ms. Haun, and her parents, and she did actually make payments on that. I believe they were $1,000 a month for some time. However, those payments ended around, I believe, 2017, and by the time of this divorce, payments had not been made in an extremely long time. So as far as verbal agreements on, so that's the status. I believe there was a verbal agreement on that between Ms. Haun and her parents. there was no verbal agreement to repay the $19,670, or there may be a dispute about that. There's some dispute possibly about what testimony stated, okay, I was trying to repay it or I was going to repay it, but I think at the time of the, say, $19,670, there really wasn't a, quote, verbal agreement. The $19,670 was taken by Ms. Haun from her parents' business by her writing a check and her sister Gina writing checks to the Hauns. They didn't have permission. The Hauns only figured this out at the end of the year when they got together with their bookkeeper and decided they would pay that back to the company. So then on the $120,000, did I already address that? Excuse me. Yes, so I think I've addressed all so there were verbal agreements on the $120,000 too. And the way that was that the $120,000 that had been paid directly to the Imogene Gregg estate would be repaid back to the Whaleys, yes, back to the Whaleys under the same terms and conditions as the demand note that the parties had executed with Mr. Gregg. However, and that is the crux of the issue on that. Did the payment by the Whaleys extinguish that demand note, thus resulting in perhaps an enforceable oral agreement, but not a suit on a note, rather a suit on a loan? And being a suit on a loan is significant because the statute of limitations to recover monies from a suit on a loan is 6 years. In order to recover from a demand note, the statute of limitations is 10 years. So that's really what all of us here have been arguing over throughout this appeal. I would submit that the case of Wilson versus Harris, which was decided by the Eastern Section Court of Appeals here in Knoxville in 2009, is very instructive on this issue. I think both parties agree it's instructive. We just have a different take on how so. Specifically, I believe it's instructive because the Wilson versus Harris court went through, and I don't know if any of you were on there at that time, but anyway, went through an analysis as to which statute of limitations should apply. And they decided that since it was basically an oral agreement to repay, that it really didn't fall within the demand note statute of limitations, because although demand notes are not defined at TCA 28.3.109, they are defined at TCA 47.3.104E, basically as an instrument that's in writing. So, that's an instrument. An instrument connotes some type of a document, I would submit. So the issue on the $120,000, I'll call it a loan for the purposes of this argument, is whether or not the 6-year statute of limitation applies or the 10-year. And our position is fairly simple. It's basically that the Gregg note was extinguished when the check from Janet Whaley went to the estate of Imogene Gregg. The parties did agree that they would pay interest-only payments and that they would operate under the same terms. I don't think specific reference was made that it would also be a demand note, but in broad general terms, they agreed that they would be operating under the same terms as the Gregg note. The Hauns made maybe 4 or 5 payments of interest only pursuant to that note. And those payments went from about February of 2011, shortly after the note was paid by the Whaleys, up until, February or March of 2012. So after 2012, there was no money paid on the Gregg note. So Mr. Haun's position today is that the statute of limitations on that note ran 6 years after the note was taken out, which was January-ish of 2011. So that statute of limitations would have run in January of 2017. The Whaleys never brought suit until this divorce was filed by their daughter. And I understand that everything's sunshine. I'm sorry?
Was there any request for payment during that time?
There were requests for payments on various of these, specifically regarding the $120,000 note. Mr. W.C. Whaley testified that he spoke with Mr. that he spoke with Mr. Haun at a Christmas dinner, when the family had gathered at Christmas dinner about making payments, and that Mr. Haun indicated that he would start making some payments. Okay. But Mr. Whaley was not able to pinpoint when that conversation took place. He also did testify unequivocally that he didn't recall having any other conversations with Mr. Haun about repayment on that debt. Ms. Janet Whaley testified that she had never had any conversation with Mr. Haun about repayment of the $120,000 debt after the initial transaction in 2011. So that's the crux of the issues on that. Let me jump over real quickly, unless anyone has any other questions about that, to this $109,000 note. I think everybody's in agreement that the note really followed the house, and that the court actually awarded that property to Ms. Whaley, but also said that she would have to pay the note. The problem is that, most respectfully, the court also entered a judgment against both parties jointly and severally for the entire amount of all the monies combined, which is in excess of $297,000. So my client basically is pretty crippled by having this judgment out there that makes him jointly and severally liable for monies that the court really didn't even say he should have to repay, but by making this sweeping finding and judgment against him has pretty much crippled him in his business. He can't really qualify to do much of anything with his used car dealership by, have a floor plan, financing floor plan, and things like that. If there aren't any other questions about that, do I need to go to the issue regarding whether the notice of appeal was timely filed as to the Whaleys, or may I address that on my rebuttal?
It's up to you.
Okay, thank you. I think I will do that if that's okay, and I'm running out of time. Alimony. There were 3 adults living with the wife at the time. 2 of them had a job. One of them was the boyfriend of the girlfriend who had a job, and the court still awarded alimony in futuro and found that there was no rebutting the presumption that she was contributing to their needs. But we respectfully submit that if she wasn't contributing to theirs, they were contributing to hers. Thank you.
Thank you. Mm-hmm. Yes, sir. Mm-hmm.
Your Honors, I'm Andy Brown. I represent Kristie Haun in this appeal. Ms. Haun was obviously married to Mr. Haun for 27 years, and certainly I think the record reflects that during the last few years of that marriage, things became very, very difficult and tumultuous, particularly related to the issues surrounding Mr. Haun and his finances, as well as a paramour that he took in to ultimately wreck this relationship, and that's something that the court found. Starting first with what counsel brought up last, the issue of alimony. The court did award alimony of $1,250 a month in futuro to Ms. Haun because of the need that had been demonstrated, obviously, throughout the course of the trial, and also Mr. Haun's ability to pay. The court went through all of the statutory factors and almost resoundingly found in every single category that Ms. Haun was a candidate, eligible, and in need of the alimony that was ultimately awarded. This issue with the presumption really is very simple. Ms. Haun, one of the adults living in her house was her 18-year-old son who had just graduated from college. Testimony during the trial is that he had suffered, quite frankly, greatly as a result of this divorce and the issues that the husband had caused. As the record reflects, there's some 30-odd counts of contempt in this case, which Mr. Haun was found guilty of. 27, I believe, were criminal. It may have been 29. He used some profanity in court that resulted in 2 additional. But nevertheless, Mr. Haun's conduct resulted in the son being troubled, having to stay at home. Ms. Haun's testimony and the record as a whole reflects that he was not providing any support to that home because of just the general circumstances surrounding him. The other 2 people were Ms. Haun and Mr. Haun's daughter, who was an adult, and she worked in social services. She had just graduated from college, and she had lost, along with her boyfriend, their home through circumstances beyond their control. They also were not contributing to anything in the home, but they were leaving within a very short period of time. So the court found that the presumption of support obviously had been overcome. Great deference was afforded to the credibility of Ms. Haun and her witnesses. Husband was found not credible almost entirely, and that was something that the court placed great weight on when it was making its findings. We believe that that order obviously should be upheld. There's nothing, I think, in the record to reflect that the court abused its discretion or went beyond what the law would provide. And another just important point briefly, the amount of money, $1,250 a month, that was awarded, and there's a previous order in the file when Pendente Light Support was awarded, was directly related to the amount of the mortgage on the property Ms. Haun was ultimately awarded, which was her family home. She took out that mortgage because Mr. Haun developed such terrible financial problems that she did everything she could to try to support her family. And so then she saddled herself with $1,250 a month on a house that was completely unencumbered. The court found that amount was what was necessary for her to continue with her pre-divorce lifestyle, i.e. keep her home that she had been in. When we look at the issues which counsel described as the most contested, and these are the debts that are claimed owed to Ms. Haun's parents, my client was saddled with these debts as well. We are not standing here before this court today saying that the court did not rule correctly. My client's position throughout this entire trial from day one till this very moment is that every single amount of money that they received, Mr. Haun and Ms. Haun, was received from their parents or from her parents as a loan with an obligation to pay that back. Now, the question about whether or not there were writings to support these is a good question. And specifically with regard to the $120,000 demand note, as it's been characterized, that was a written document. There is a note that it's called the Gregg note. It's in the file. And it set forth the agreement that these parties ultimately entered into related to the repayment of this debt. Just simply put, Mr. and Ms. Haun agreed to take a loan, this demand note, from her uncle in order to buy a car lot, which was this business that's referenced. They did not pay that note on time, and after the gentleman, Mr. Gregg, died, his estate comes and says, you owe us the money or we're taking your car lot. The Whaleys stepped in and said, we'll give you this money under the exact same terms as this Gregg note, and you can pay the interest on it. And they wrote a check in order to signify that agreement, which the Hauns accepted. That car lot continued on, and to this day is the source of income for Mr. Haun. Respectfully, I'll submit that if this court was to overturn the award, or better yet, the ruling as to this $120,000 demand note, well, that results in Mr. Haun, who got the debt as part of this divorce, receiving an asset, i.e. the business, without having any debt associated with it. It automatically creates an inequitable division of the parties' debts and assets. And that's important also for purposes of the alimony award, because the court found at trial that if we didn't have the alimony award, it would be inequitable to award husband the business. So Mr. Haun's ultimately trying to achieve an objective where he has a substantial advantage walking out of this divorce, which he undoubtedly caused. With regard to the $78,000 note, that was an oral agreement that the parties reached. That specifically, I think that the words used by Mr. Haun or Ms. Whaley perhaps at trial was that he called her up and said, Mama, I need $78,000. And he needed $78,000 then for a floor plan at his car dealership. Excuse me, I've got a little bit of a cold lingering from Thanksgiving. But he needed the $78,000 to pay on a floor plan, which was due, and I believe this is a scenario where there was a discussion about swapping checks. So what that essentially means is that he had written more checks than he could cash, and so he needed that money now or he was going to have problems. Ms. Haun was not involved with that in any way, shape, or fashion, but he needed it, and that was a debt that they took on and that they agreed to pay back. And that was something that they endeavored to do. The court properly found that that was a debt that should be assessed against them both, frankly. The $19,000, there is no writing. It is correct. Counsel is accurate that these are checks that were written by Ms. Haun as well as Ms. Haun's sister related to, again, things associated with Mr. Haun's business. Interestingly, about the proof at trial on these issues, though, is that Mr. Haun First, in all these debts, he never denied before the divorce gets filed or the Whaleys bring suit that he owed these amounts of money. He always tried to continue to lead it on that I was going to pay it back, or, I'll get you money, or he would make tiny payments. But the $19,000 he said was a gift. He said all these were gifts. But at trial, he came forward and said, well, I've paid all that back. He admitted that this was a debt that he owed. But now here today, and obviously on his appeal, he says it's something that shouldn't be assessed to him. He just was not credible at all in any circumstance before the trial court, and that was the proper person to obviously judge those circumstances. The $109,000, so again, with the $19,000, the court properly assessed that loan and found the parties responsible for it, Ms. Haun and Mr. Haun. He admitted that he had paid money back on it, though he could not show any proof that he had done it. His candor with that issue, I think, speaks to his responsibility for that debt. The $109,000 for the Griffith Drive properties, again, this is, and counsel pointed out, the court awarded a joint and several judgment against the parties for this amount. The story is very simple. It is property adjoining the marital residence that my client ultimately received in this divorce. The $109,000 was used to purchase it. Mr. Haun wanted this property. Ms. Haun wanted this property. Mr. Haun was instructed, and Ms. Haun agreed that he should go and put down $5,000 in order to purchase it, and then the rest of the money was coming from the Whaleys in order to finalize the purchase price. That property ultimately gets transferred into my client's name alone. The court in the division of assets appropriately found that it was transmuted to marital property. It was ultimately awarded to Ms. Haun, with her being subject entirely to the debt, which at the time of trial, I believe, was about $85,000. So there had been some payments on that during that period of time as well. I believe that pretty well covers the topics that were addressed by opposing counsel. There's some information in the record related to the value of some used cars, scrap cars that are out on the lot. The uncontroverted, credible testimony came from Ms. Haun as to the amount and value of those vehicles. I don't know how you can get any better than I went out and counted the vehicles to determine how many actually existed. Mr. Haun wanted to throw up a red flag about, I don't own all of them, but he didn't produce any evidence to support that whatsoever. Again, the court weighed Ms. Haun's testimony as being the credible part of that. I'm happy to answer any questions the court may have.
I hear none.
Thank you very much.
May it please the court, I'm Franklin Chansey, member of the Bradley County Bar. I'm here on behalf of the Appellees, Janet and William C. Whaley. I think the starting point in this matter has to be the court's findings with respect to the credibility of the appellant, Jason Haun. The court specifically found that in every single instance where there was a dispute between the testimony of Jason Haun and either my clients or his wife, the court was resolving those differences in favor of the appellees in this case. The court found Mr. Haun to be completely incredible in terms of his testimony. That is relevant on multiple issues regarding to these notes that we're talking about. The $120,000 Greg note one, the court found in particular that the parties agreed that the terms would be the same as the Greg note. There were partial payments made on that note. And because of that, the statute of frauds is not applicable to that. So that finding by the court that Mr. Haun was not credible with respect to his statements about whether or not the terms of the Greg note applied were resolved in favor of my clients. And for that reason, the finding that this was a demand note with a 10-year statute of limitations is the correct ruling by the court. And so there wouldn't be a statute of limitations issue with respect to that. The second note that is involved here is the $78,000 note. And the issue raised on appeal in the brief by Mr. Haun simply says that, and I don't want to misquote it, but it says, whether the 3-year statute of limitations for conversion, I'm looking at the wrong one, whether it should have been assessed solely to husband for repayment. It wasn't assessed to Mr. Haun for repayment. The court's orders indicate that all of these judgments are joint and several against both Mr. and Mrs. Haun. So that's the only issue raised on appeal with respect to that note, so I don't think that that would apply at all. With respect to the $19,670, Mr. Haun's testimony was all over the board. First, he denied that there were loans. Then he testified that he had repaid those documents before then changing his testimony again. It takes us back to my original point that the court simply found his testimony not credible and chose to believe the testimony of my clients, and in this particular case of Mrs. Haun as well. So that judgment also would stand. Now, the appellants also raised the question of whether or not a 3-year statute of limitations for conversion would apply. Unfortunately, Mr. Haun did not raise or argue that position in the trial court. That was never presented as an argument by him, and therefore it would be our position that is waived on appeal. Finally, the only issue with respect to the $109,640 is whether it should have all been attributed to the wife. I don't know really what the argument for that is. Mr. Haun participated in the transaction. He provided the down payment money when it was made. Payments were made on the note at various times during the process. And so the finding that it was a joint and several liability of the two Hauns, I think, is entirely the appropriate one. What the court chose to do about allocating it between those two does not affect my clients whatsoever. They have a judgment against both parties that they could collect in any manner that they chose to follow that. Does the court have any questions about the notes?
I hear none.
All right.
Thank you.
Your Honor, the remaining argument has to do with whether or not the notice of appeal was properly filed with respect to my clients. I think that this is essentially an issue of first impression before this court. The rules in this case require a notice of appeal to be filed. It requires on the appeal that the parties be identified, who's going to be involved in the appeal, whether that's the plaintiffs or the defendants, and then it requires that service be accomplished on the appellees, if you will, within 7 days from the filing. In this particular case, that did not occur. It is correct that the notice of appeal was filed within a timely fashion. However, the form that was submitted by the appellants in this case failed to list my clients, Mr. and Mrs. Whaley, as appellees on the matter. In addition to that, they were not served with the notice of appeal within the time provided under the rule. Now, it is correct that some 7 days later, approximately, from the deadline that would have been imposed, that counsel made a telephone call to my office, but I don't think that's really relevant for the court's consideration. That's what the order, the rule actually requires. The question is whether or not the appellant in this case has established what the court has called good cause for suspending the application of the rules in this case. Typically, we see things like illnesses, courthouses being closed, things like that that aren't appropriate. In this particular case, what we have is a notice of appeal that was filed timely, and that notice of appeal specifically references 3 judgments that were being appealed from. And those judgments specifically list my clients as parties in the case. There's no requirement that you appeal as to each party in the case. That's the purpose of the docketing information that's used.
And thank you, sir. I think that concludes your time.
Thank you.
Yes, ma'am. Your rebuttal.
Thank you very much. I will briefly touch on the issue regarding the timely filing of the notice of appeal or lack thereof as to the Whaleys. Today's the first time that I'm hearing that it's now accepted that the notice of appeal was actually timely filed. In the briefs before the court, the only basis for the appellees to say that the Whaleys were not appealed timely, or the judgments against them were not, was the fact that it was filed on September 1 rather than July 25th. Sorry, it took me a minute to get that out. So there was the last order entered in the case was on August 2nd because there had been motions to alter or amend filed. And so, but the judgments were clarified, the judgments in favor of the Whaleys were clarified on June 24th, that order that was entered on June 24th. So up until this moment, no disrespect intended, but up until this moment, the position has been that the reason why the appeal against the Whaleys should be dismissed is because it wasn't filed by July 25th, which would have been the time frame. However, this honorable court had already found in an order that it entered in this matter, because this had been filed before oral arguments, this court already found that because a motion to alter or amend was filed, that the time actually did run on August 2nd, and so the notice of appeal being filed on September 1 met the requirement. So again, so I was a little surprised to hear that today. The reason I'm bringing that up is they really haven't alleged any other ground up until today for dismissing the Whaleys complaint, except that it wasn't filed on July 25th. So now we're talking about good cause when that really hasn't been brought up before. So let me just address real quickly. When you're talking about filing a notice of appeal, there's kind of two tracks. One is the form that's on the AOC website, and one is the rules. The rules are the thing that we really go by, and the rules don't require all parties to be identified in the notice of appeal. The rules only require that the appealing party be identified and that the judgments from which that party is appealing be identified. And so those things were done because Mr. Haun was the appealing party and he identified the three judgments from which he appealed. So Rule 4, I believe it's Rule 4 that states that, might be Rule 3, is where that comes from. The form itself does have a spot on there for additional parties. It is the tiniest print ever, but it does have a spot for additional parties. You can turn it over if it has a spot for one party. And then it says if there are additional parties, list them on a separate piece of paper. Okay, the rule doesn't require that. The filing of the notice of appeal meets the by the date 30 days after the last order entered meets the requirements in that regard. And I've basically briefed the rest of those issues in my brief, and I won't keep going about it. Thank you.
Thank you very much. Thanks to both sides, the attorneys, for your presentation. Your case has now been submitted to this court.
Thank you, Your Honor.